The topic is the Civil Rights Act of 1964 and the Tennessee Human Rights Commission. And we're talking to the Executive Director of the Tennessee Human Rights Commission, Ms. Amber Gooden. And of course, Ms. Gooden, before we had our break, I think I sort of interrupted you when you were explaining some of the exceptions in reference to the difference between the federal statute and statutes of various states. Let's continue. Let's give you an opportunity to continue that.
As I was saying before the break, that under Tennessee law, we begin looking into or investigating complaints when an employer has 8 or more employees, as opposed to on the federal side where it is 15. Then that allows us really to deal with, when you think about it, more smaller businesses as they're concerned. On the housing side, for instance, under housing discrimination, we can also investigate, and people can file complaints as it relates to commercial real estate, not just residential real estate. Another difference on the federal side is that under federal law, a landlord or someone would have to own 4 or more properties. Under Tennessee law, all is required is one property and so forth. And I find that really, especially on the housing side, that people really don't understand and really know many times what their rights are and how they are being discriminated and victimized.
Well, now, what are some of the rights in terms of housing that you recognize that, and some of the violations that generally come across your desk at the Tennessee Human Rights Commission?
One of the biggest areas and complaints that we find is we're educating more, people are finding out, and that is in the discrimination of what is called familial status. Familial status is discrimination against one who has children. People are still, many times we find that people still believe that someone can advertise or say no children and so forth, when actually, in fact, that is against the law. Unless an apartment complex or a residential facility has sought a designation from Medicare as being, you know, senior living and so forth, and especially for seniors, it is unlawful to turn someone away because they have children.
I mean, now what would be the rationale for a landlord not to accept children? I mean,
many times people believe and think that because one has children, that they will not be as careful with their property and will tear it up. So let's take a scenario. If you were coming to, let's say I were coming to rent from you, and I brought my 2 or 3 children with me, and I saw that there was an ad in the paper for an apartment. For you to tell me that it was not available for rent because in the back of your mind you're saying, I don't want those kids tearing them up. And then the very next person comes and they don't have children and you rent to that. If I found that out or suspected that that was the case, and I go and file a complaint, then we would initiate an investigation and begin looking into the records of that landlord, what kind of ads they've placed, might even send in what we call testers. Testers are people that are approved by HUD, that have been through training and so forth, to mirror the discriminatory situation that we're looking into. They write up a report, it's unbiased. We usually go through a third party to do this. They're not people on our payroll. And through that then would confront then the landlord about the findings and so forth, and attempt then to get some type of relief for the complainant. What many people don't understand many times is that, especially in smaller rural areas where affordable housing is so limited, when one does this, it might make the difference in somebody having